Why don't we get everyone up? And we have an order of speaking. I'll go first, followed by Senator Franken, and then Kevin and Jason, or I'm sorry, Jeffrey, Jason, Aniela, and Peter.
MC? You just MC.
Okay.
You know.
I'll do that. I don't think I really know how to MC. Isn't that something people in the entertainment business do?
Yeah, okay. How about you're the host? No? Okay. Just be yourself. You'll be fine.
Okay. First of all, let me really very sincerely thank the extraordinary men and women who are here today and thank all of you for your service. I just left actually one of my sons who is serving and explained to him why we're here today. And he was very inspired that we have your support and that you would come forward to make the statement that you do by your presence here today. So I am tremendously grateful for myself and Senator Franken, and he has been a longtime champion of this effort. Congress has long provided our reservists and military personnel with rights, among them rights to be reemployed when they come back from missions in their capacity as reservists. Americans' military missions can't be accomplished without the reserve components. We know in these wars more than any before how important our reserve components are. And so veterans like Kevin Ziober, who are called away from their civilian jobs, perform an essential mission for our nation. Since September 11th, 2001, more than 900,000 members of the reserve components have been mobilized. The Uniformed Services Employment and Reemployment Rights Act, commonly known as USERRA, guarantees service members the right to return to their civilian jobs after they serve. That's a right. Can't be denied, can't be abridged. But I know as a law enforcement guy that rights are often disregarded unless they are made real by law enforcers or by the individuals themselves when they use their voices and legal tools to stand up for their rights. And USERRA gives them those rights, critical enforcement rights, such as the right to bring a claim to court and the right to receive enforcement assistance from the Department of Labor. Without those strong substantive procedural protections, it would be impossible for millions of Americans to serve in the National Guard and reserves to protect our homeland and advance America's national interests. USERRA has one of the strongest employment laws in the country. It allows a service member to file a USERRA action in any district where the employer maintains a place of business. That's very important for service members because they live a lot of different places. If they have to bring a claim in only one place, it can be difficult and costly for them. It has no statute of limitations, as Congress recently clarified in an amendment enacted unanimously and signed by the President in 2008. And under USERRA, service members cannot be charged any filing fee or court fee. Those rights are very important, but unfortunately, and very importantly, USERRA's strong enforcement rights are routinely undermined by arbitration agreements. Most people in the public have no idea what an arbitration agreement is, but it can severely undermine, in fact, eviscerate these strong rights. The problem is that arbitration agreements are routinely used under a misinterpretation of the law that enables employers to abridge those rights, and they can sometimes discriminate against reservists and others in a similar position. So our legislation would correct any misinterpretation of the current law. More than 28 uniformed service groups and VSOs support the Justice for Service Members Act, which would assure that these unconscionable practices are prevented and corrected, misuse of arbitration agreements and misinterpretation of the law. I'm grateful to the Veterans of Foreign Wars, the American Legion, the Vietnam Veterans of America, the Iraq and Afghanistan Veterans of America, the Military Officers Association of America, the Reserve Officers Association of America, and the National Guard Association of the United States. In addition, the United States Department of Labor, Department of Justice, and the U.S. Office of Special Counsel support this clarification to protect and advance the intent of USERRA. After fighting for our freedom abroad and at home, our reserve members should have the right to fight for their job here. They should have that right without one hand or arm tied behind their back. And they should be given the support they need and deserve from the law and from law enforcers generally. And that is why we're here today and why I'm so proud to be with the group that we have and to introduce Senator Franken.
Thank you, Senator Blumenthal, and thank you to all the men and women here who have served in our armed services. I'm the only one here, I think, who hasn't. And I came of age during the Vietnam era when Senator Blumenthal did, and I had a 2S deferment because federal government felt that it was in our nation's national security interests for me to finish college and pursue my chosen career, comedian. For years now, Senator Blumenthal and I have collaborated along with a growing number of our colleagues to combat the widespread and harmful impact of forced or mandatory arbitration. And today I'm proud to join him in urging for the passage of the Justice for Servicemembers Act to ensure that our nation's heroes are not subjected to employment discrimination based on their service to our country. From nursing home contracts and employment agreements to credit card and cell phone contracts, forced arbitration agreements restrict Americans' access to justice by stripping them of one of their most fundamental constitutional rights, the right to have their claims heard in a court of law. And as you can see today, these agreements affect everyone, even those in the armed forces who have selflessly committed to serving our country and fighting for America's safety and well-being. No man or woman who leaves behind family and friends to answer our country's call to duty should also be forced to walk away from secure employment and thereby upend their financial future and the well-being of their family. But that's exactly what's happening. Employers across the country are increasingly relying on forced arbitration to discriminate against service members and end their employment based on their military service. That is not fair, and it goes against our nation's longstanding commitment to honor our military members and veterans. Now, to reverse this troubling trend once and for all, I stand in strong support of the Justice for Service Members Act. This legislation simply clarifies Congress's intent when it passed USERRA, the Uniformed Services Employment and Reemployment Rights Act, and restores service members' right to have their claims heard in a court of law. Now, I believe that there is actually reason to hope that this bill will pass. I'd like to remind everyone that this is not the first time Congress has acted to protect members of our armed services from the unfair practice of forced arbitration. In 2007, former Republican Senator Jim Talent, a conservative Republican from Missouri, advanced a bill that prohibited predatory lending practices, including a prohibition on enforcing mandatory arbitration clauses in financial agreements against service members. This amendment passed the Senate unanimously and went into effect later that year. In 2009, Congress took up an amendment that I introduced to the National Defense Authorization Bill in the fall of that year to prohibit defense contractors from compelling arbitration against their employees for claims of discrimination and sexual harassment and sexual assault. Once again, this amendment passed with broad bipartisan support, and it has been included in the Defense Appropriations Bill every year since. If these bipartisan actions are any indication, the Justice for Service Members Act should have a clear path forward. I look forward to working with my friend, Senator Blumenthal, to secure that path and see that this bill is passed into law. Thank you all for being here, and thank you to all our men and women who have served this country so faithfully.
Thank you,
Senator?
Thanks. Thank you.
My pleasure. Thank you all.
We're now going to hear from Kevin Ziober, who is a United States Navy reservist. The day before his deployment, Kevin's employer told him that he was fired and told him that his job would not be available to him when he returned from Afghanistan. His testimony, I think, was one of the major reasons why I was so intent on moving this bill forward. And I thank him for sharing that story and for being here today. Kevin?
Good afternoon. I want to first sincerely thank Senator Blumenthal and Franken for introducing the Justice for Service Members Act. The language of USERRA is meant to protect the substantive and procedural rights of reservists, and this act will help clarify that language. I'm also glad to see there's so much bipartisan support for this legislation to help protect the rights of our National Guard, Reserve, and veterans. My story is a personal account of what happened to me as a reservist. I lost a job because of the language of USERRA. In 2008, I joined the Navy Reserves. I was hired by BLB Resources, a private employer, in 2010. From 2010 to 2012, I helped the company grow from 18 employees to over 90. 6 months into my employment, I was forced to sign an arbitration agreement, which made no reference of USERRA. In 2012, I received orders to deploy to Afghanistan for 12 months. I gave my employer notice as required by USERRA. A few weeks later, on my last day of work, they hosted a farewell party for me where 40 of my colleagues had gathered to wish me farewell with a cake, navy-colored balloons on the walls, camouflage netting on the doors, cards and gifts on my desk. It was a great feeling and patriotism to be sent off that way. A few hours later, about 4:45 that same afternoon, I was called into the Human Resources Department, where I was summarily fired and told my job would not be available to me upon my return from deployment. I went and did my tour of duty, came back in 2014, and filed a USERRA claim in the district court in Southern California. At that point, BLB Resources submitted a motion to compel arbitration. The judge agreed, and my case was dismissed in favor of arbitration. The case, fortunately, didn't end there. through my legal team and support of other organizations, we now have it up with the Ninth Circuit Court of Appeals. But that's why I think this legislation is so strong. It's so important for our service members and veterans to help clarify the language of USERRA and Congress's original intent to protect the service members. As Senator Blumenthal mentioned, USERRA gives rights to service members that arbitration ignores. Some of those are, under USERRA, members can file in any district court where they have a place of employment. Reservists and Guard members move around a lot. That makes it very convenient for us. There is no statute of limitations, so we're not bound by time restrictions. We are not obligated to pay filing fees, which can be sometimes very challenging for certain members of the military. And we're also not obligated for employers' fees and costs, which again can serve as a deterrent for people enforcing their rights. I think to sum it up, arbitration is incompatible with USERRA. The Justice for Service Members Act doesn't create any new laws. It simply clarifies the intent of Congress by removing the ambiguity from interpretation by the courts. The Justice for Service Member Act gives Guards and Reservists the confidence to also go and serve their country when they're called to duty, knowing that their jobs will be protected when they return home. This bill helps strengthen the armed forces and protect our national security by making it possible for millions of Guards and Reservists to both serve in the military and hold civilian jobs and keep our homeland and national interests protected abroad. Thank you.
Thank you. We're going to be hearing later from Peter Romer, who is Kevin's lawyer, about some of the technical and legal aspects here. But let me just speak for a moment. As a trial lawyer, arbitration is an aggrieved person's nightmare because the rights that a person otherwise would have in court are so diluted and disregarded. Why is that so? Because an arbitrator or a panel of arbitrators is chosen often by the person whom you're suing, or at least he has a say in it. So it's a little bit like the defendant choosing who the judge is going to be, except, and here's the other part of it that is nightmarish, there aren't the same rules of evidence, rules of law that apply to procedure. It's kind of like the normal rules don't apply, and the decision is essentially unreviewable. So it's kind of like a dartboard. You throw the darts, you hope they make it to the right place, but usually they don't. And one way or the other, it abridges the fundamental rule of law that is so important to implementing USERRA. So I should have made that point right at the beginning. That's really why arbitration is so nightmarish for people whose rights are abridged. We're now going to hear from Jeffrey Phillips, who, I should say Major General, retired Jeffrey Phillips, who is the head of the Reserve Officers Association.
Sir, thank you for your family service.
Thank you.
Good afternoon, everyone. Thank you for being here. The Justice for Service Members Act would help ensure that members of the Guard and Reserve have full and untrammeled access to their USERRA rights within the intent of the original law. More than 900,000 members of the Guard and Reserve have been mobilized for the war on terror. Some 1,200 have lost their lives in service. That's just since 9/11. Members of the Guard and Reserve deserve the full employment and reemployment rights afforded by USERRA. Binding arbitration, as we have heard, as a condition of employment strips away their choice and their rights. ROA thanks Senator Blumenthal and Senator Franken for championing service members' employment and reemployment rights, and thus the continued strength of our military and the families of our military members as they in turn serve America. We also thank those employers across this country who support USERRA and the members of our military who serve in their employment ranks. Thank you very much.
Thank you. I'm very pleased that we have with us Jason Johns, who is from the distinguished member of the Military Order of the Purple Heart, and John McElligott of the Commissioned Officers of the United States Public Health Service.
Thank you, Senator. Good afternoon. My name is Alex Morosky. I'll be speaking on behalf of Jason Johns. And like many of the other veteran service organizations here, I'm here on behalf of the Military Coalition, and I'm also the Deputy Legislative Director of the Military Order of the Purple Heart. MOPH is the only congressionally chartered veteran service organization made up entirely of combat wounded veterans. But we stand up for all veterans. We stand up for all active duty, and we stand up for the reserve component. The reserve component, which is most affected by the forced arbitration loophole in USERRA that this bill seeks to close. As many have said, under USERRA, returning service members must be promptly reemployed in the same positions they would have attained had they not been absent for military service. If an employer doesn't offer the same pay, benefits, or status when a service member comes back from duty, USERRA allows the service member to hold the employer accountable for these violations in court. Seems pretty straightforward. However, some service members have been unable to exercise their USERRA rights due to increased use of forced arbitration clauses buried in the fine print of employment contracts, usually presented on a take-it-or-leave-it basis. These clauses preclude access to the judicial system and instead funnel the service member's employment discrimination or wrongful termination claims into private, costly arbitration systems set up by the same employers. The Justice for Service Members Act gives service members the ability to pursue their USERRA claims in court while preserving the option to enter into arbitration agreements after a dispute arises if they choose. The Military Order of the Purple Heart strongly urges Congress to quickly pass Senator Blumenthal's Justice for Service Members Act. It's important for Congress to guarantee that the men and women in our nation's uniformed service can exercise the rights Congress intended for them, but they currently are denied. And it's important to pass it for people like Kevin and all the others who are affected by this. At this time, I'd like to turn it over to John McElligott for his remarks.
Thanks, sir. Good afternoon, ladies and gentlemen. My name is John McElligott. I'm the Deputy Executive Director of the Commissioned Officers Association of the U.S. Public Health Service. I also happen to be an Army reservist, an officer in a civil affairs unit, and I co-chair what's called the Military Coalition, or TMC, Guard and Reserve Committee. The Military Coalition, or TMC, is a consortium of uniformed services and veterans associations representing current and former service members, their families, and survivors. TMC strongly supports the Justice for Service Members Act, introduced by Senator Blumenthal. We also have a House version as well. This important bicameral bill is a concise, straightforward bill which ensures that our service members and veterans can enforce the rights afforded to them under USERRA. Here's a copy of a letter from TMC showing our support for the bill, the House version and the Senate version introduced by Senator Blumenthal, with all the signatures on the back here. I note that USERRA stands for Uniformed Services. That means that it includes the Public Health Service, which is one of the nation's 7 uniformed services and led by the U.S. Surgeon General. The mission of the Public Health Service is to protect, promote, and advance the health and safety of the nation. Today's 6,700 men and women serving in the Public Health Service are called America's health responders. You've seen things in the news about Zika virus. There's a problem in Flint, Michigan, health concern out there. Last year, we had the Ebola outbreak. The Public Health Service received a Presidential Unit Citation for their outstanding work on the Ebola outbreak. They're deeply involved with health issues behind the scenes in clinical and non-clinical roles throughout the federal government and state health departments. So they do an awful lot for the United States, and they are covered by the protections of USERRA. Every year, there are dozens of public health service officers and other uniformed service members who have to leverage USERRA to maintain their rights as service members and push back against discrimination in hiring practices. As Senator Blumenthal and Senator Franken mentioned before, there's a long history of USERRA receiving broad bipartisan support, and we want that tradition to continue. So our organization, COA, will work with our friends in the Military Coalition to encourage both Republicans and Democrats to co-sponsor this bill. Thank you very much. I'll be followed by Senator Aniela.
Thank you. Very pleased to introduce Aniela Szymanski, who is the Deputy Director of the Military Officers Association of America. Thank you.
As a reservist myself, I'm all too familiar with the struggles that come along with balancing a civilian and military career. And I've also experienced negative ramifications in past civil employment due to my reserve obligations. That's why I feel, and why Military Officers Association of America stands behind this legislation, and thanks Senator Blumenthal and Senator Franken for taking a stand on behalf of reservists. There should never be a circumstance when a reservist is asked or forced to choose between their civilian career and serving their country. And all too often, I hear from our members, as well as based on my own experience, that this becomes a very real choice. And more often than not, reservists are forced to choose their civilian career because the choice is between serving their country and feeding their family. It's disappointing that it has taken a literal act of Congress to force employers to do the right thing in standing up for service to our nation and voluntary service to our nation for those who take on that obligation freely. Although that's disappointing, I am very encouraged by the fact that Congress is doing so, and Congress will stand behind those who choose to serve this country as well as choose to pursue a civilian career. Thank you again, Senator Blumenthal. And Military Officers Association strongly encourages all members of Congress to stand behind this bill and get it passed.
Thank you. Great job. Thank you. And last among our speakers, Peter Romer, who is Kevin's attorney and an expert on USERRA. And I'll ask him to please come forward.
Thank you, Senator. Thanks for your leadership. About a decade ago, I was working here in the Senate for Senator Kennedy, who was the chair of the Labor Committee. I knew very little about USERRA. I didn't serve, and frankly, I'm in awe of the service of your family and everyone here. It's an amazing thing that so many people volunteer to fight for their country, to serve, and they don't ask for anything in return but respect from the rest of us. I learned about it because Senator Kennedy read a newspaper article in the Washington Post that said hundreds of thousands of service members were serving in Iraq and Afghanistan, returning and not getting back to their jobs. And he knew there was a law, wanted to know why, what was happening. And we found out that the Department of Labor was doing a poor job of investigating and resolving these cases. There were some problems with the statute not being strong enough. There was a question about whether there was a statute of limitations period. And we went to work. It wasn't a Democratic idea. It wasn't a Republican idea. We worked together. We worked with Senator Murkowski. We worked with Senator Akaka, who at the time was the chair, and Senator Burr as well. And we worked on bipartisan legislation to clarify the law where judges had found that it was ambiguous or they couldn't follow the intent of Congress. We passed amendment after amendment to make sure that the law worked for service members and veterans and so that they can enforce all of their rights. We expedited the process for the DOL investigating claims, and it now works a lot better. There still are challenges that service members face in enforcing their rights under USERRA. We see discrimination reducing to some extent in our society across the board, but in the military context, we see the most appalling, egregious violations. I don't think I've seen a more black and white violation where Kevin had this cake presented to him to say, we support your service, best wishes, at noon, and they fire him at 4:45. None of us could believe it when we actually learned about this and took his case. We're representing another service member, Rodney Bodine, in the 11th Circuit in an appeal where he signed up, he was in the Army Reserve, he took a job, and they said, military folks don't work well here. They just don't work well here. And then when his contract was about to end with the Army Reserve, they said, if you re-up your contract, we're going to fire you. And he ended up re-upping his contract, extending it with the Army Reserve. They fired him immediately. They sent him packing. That should never happen in America. But to add insult to injury, when people like Kevin Ziober, Rodney Bodine try to enforce their federally protected rights, they're told, you've got to go to a private arbitrator. There's no place for you in court. And so that leaves us the question now, why are we here? Why are service members being told they can't enforce their rights? And unfortunately, we have two federal circuit judge courts, the Fifth Circuit and the Sixth Circuit, that have said that Congress wasn't clear enough in expressing its intent to ban arbitration. I'm going to read to you what Congress said, because to me it's pretty clear, and I think to Senator Blumenthal it's pretty clear. They said, this is in the House report, which was the leading report on when Congress passed USERRA. They said, this section would reaffirm that additional resort to mechanisms such as grievance procedures or arbitration is not required. And they cited a Supreme Court case from the 1950s that had said that service members, when they enforce their rights, they're not just employees, they're vindicating the rights of all service members to be in the armed forces, and that they can't have their procedural rights taken away from them, like the right to file in court. Then Congress said, even if a person protected under the Act resorts to arbitration, any arbitration decision shall not be binding as a matter of law. That's not how arbitration works. Arbitration works, you can, by enforcing an arbitration agreement and enforcing it in a court of, once you've enforcing the arbitration award. This is the exact opposite. Senator Blumenthal's bill would clarify the law so that it would say that all rights under USERRA, not just the substantive rights or the remedies, but the procedural rights, the right to sue, and all the rights that Senator Blumenthal and Kevin mentioned earlier will be enforced by a judge, not by an arbitrator selected by their employer. And so with just several words, this bill is about 1 or 2 pages. Every member of Congress could probably read it quickly and see what it does. It restores rights. It doesn't create them. It ensures that the same rights that service members had, that our grandfathers had back in the 1950s, are still the law of the land today. It doesn't cost any money, but what we'll do is ensure that if anyone finds themselves in Kevin's shoes, where they're shown the door on the last day before their deployment, they can go into court and have a judge tell the employer, you've got to take him back immediately, not after going to an arbitrator, not after several years of litigation, but right now. That's what Congress said, and that should remain the law of the land. Thank you.
I doubt there are any questions after the great speakers we've had here, but we're more than happy to take them. Yeah.
Senator, I know you guys have Republican support in the House. I'm wondering if you've been able to pick up any factors in the Senate and how you go about doing that.
Really important and great question. And I think Peter answered that question so far as I'm concerned. This bill has enjoyed bipartisan support from the very start. The improvements have been supported by both Republicans and Democrats. As he said so well, it's not a Republican idea, it's not a Democrat idea. It is a national idea, an idea that's in our national interest. So we will be soliciting Republicans to join us in support of this bill. And I'm very hopeful that we'll have the bipartisan support that it has already received in the House when we seek it here in the Senate. I think it's an idea that is easily understandable. It can be read in 3 minutes, and the explanation can be provided in even less time. And I'm very hopeful that we'll have bipartisan support.
Is this the kind of thing you want to do as a standalone bill, or do you want to put this on? I know there's been several different Veterans First Act and
Yep.
committee and other veterans bills.
Good question. Since it has no cost, we could add it to the Veterans First bill. But if not, I see it going as a standalone, perhaps even by unanimous by UC. You know, I want to add one more point here. The employers who resort to this kind of practice are the exception, not the rule. By and large, employers respect their patriotic duty to reemploy reservists. This kind of practice is part of an outlier abuse. But for every single person like Kevin Ziober, who is doing his patriotic duty and serving and sacrificing for our nation, it means the world, or the end of the world. When an employer essentially says, you're gone, not only you're gone to serve our country abroad, but you're gone from this workplace. And that is absolutely abhorrent and unconscionable, and there should be no barriers to enforcement of that right to re-employment, even if it's the exception rather than the rule among employers, even if they're the outliers, not the mainstream. And so I am very hopeful we will have bipartisan support, because we should have very strong support from the business community. We hope to do it either as part of the Veterans First bill or independently. But one way or the other, I think it will have broad and strong support from my colleagues, and I look forward to calling on all of you to help us spread the word. So I especially want to thank all of you. Not all of you spoke, but your being here really is immensely important, not only for today, but going forward for the future. Thank you so much, and thanks everyone for being here. And we now have a hearing at the Veterans Affairs Committee where Kevin is going to be speaking, and I think, Peter, you'll be there too, and you're all welcome to join us, but the main person there is going to be Kevin. Thank you all.